Hello, everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. If you're enjoying this legal education content, please remember to subscribe. It helps the channel grow. For today's case, we're dealing with immigration and what qualifies as a disqualifying crime for an immigrant. So there are laws that prohibit an immigrant from being admitted to the United States or remaining in the United States under certain things. But then again, the question is, what qualifies within the list. And that brings us to the case of Jeff Sessions, then Attorney General, versus James Garcia DeMaya. In this case, Mr. DeMaya may or may not be a prohibited person under the immigration law, so the U.S. Supreme Court has to discuss that. Let's get started with our discussion. Happy Easter to Lessa, to Bang Arang, to Lord Cracker Squirrel, and to Opalized. Happy Easter to all of you. I'm glad you're here. The Immigration and Nationality Act virtually guarantees that any alien convicted of an aggravated felony after entering the United States will be deported. An aggravated felony includes a crime of violence, for which the term of imprisonment is at least 1 year. Section 16's definition of a crime of violence is divided into two clauses, often referred to as an elemental clause and a residual clause. The residual clause, the provision at issue here, defines crime of violence as any other offense that is a felony and that by its nature involves a substantial risk that physical force against the person or property of another may be used in the course of committing the offense. So right away, hopefully you can spot the problem. This is basically the same problem in the Armed Career Criminal Act, right? It's like, what do these terms mean? And this is the reason why the Supreme Court has basically taken, like 2 Armed Career Criminal Act or its equivalent cases every year for, quite a while, because first of all, the elemental clause just spells out a whole bunch of crimes, right? So a disqualifying crimes, here's a whole list. And then in the residual clause, they said other stuff, if it involves a substantial risk of physical force that may be used in the official. Well, what exactly does that mean? That's where the lawyers get paid, yo. Yeah, let's carry on. To decide whether a person's conviction falls within the scope of this clause, courts have applied a categorical approach. This approach has courts ask not whether the particular facts underlying a conviction create a substantial risk, nor whether the statutory elements of a crime require the creation of such a risk in each and every case, but whether the ordinary case of the offense poses the requisite risk. So this is super fun. So you could do this a couple ways, right? Depending on how you want to read the relevant language. So the language says that a crime of violence in this case is any other offense that is a felony that by its nature involves a substantial risk of force against a person or property of another used in the course of committing the offense. So the Supreme Court has interpreted by its nature to mean that Congress is trying to look at this in some sort of global, universal way. So rather than look at what the person actually did and whether or not the person committed an offense that used or might have used violence, we're not going to do that, because the question isn't exactly if the person did it, but what the offense in general does, because it's by the nature of the offense, whether or not it involves this violence. And the Supreme Court has said it's not an issue of looking at the elements of the statute, because it's not whether the statute, in order to be convicted of it, requires violence. So that's not it. If it's not an element of the statute, it doesn't matter. It's not even whether this risk occurs in every single case, but whether in the ordinary case. So what might be an example? Where there's not maybe a substantial risk of violence. Let's say, robbery, maybe a purse snatching, maybe. So that's robbery, right? So person snatches a purse, and we'll create some hypotheticals to make it even more nonviolent. Maybe the person, we'll even make it one step better. The purse isn't actually on them at the time. They have set it down by their side, but it's their purse, and we're gonna assume that that's robbery, because it almost certainly is. Maybe they have one loose finger on it or something to get the diehards, right? They have one loose, their pinky finger kind of on it maybe. And it's also like facing outwards. So the person is able to snatch this purse without even touching the person at all. This is my hypothetical deal. So yeah, it might be possible to commit this robbery with no violence at all. And maybe their back is turned, so they don't even see it happening. They're not even assaulted in the classic sense because they didn't see it. So yeah, this increasingly bizarre hypothetical, the person's purse is behind them. Maybe like their foot, the back of their foot is touching the purse. Let's go with that. The back of their foot is touching the purse, and they're facing away, and this person snatches the purse away and starts running. And they didn't even see it happen. They didn't even feel it happen. So does that count as robbery? Probably yes. Does that count as a crime of violence? Yeah. Well, maybe not in this particular hypothetical, but the Supreme Court says, well, that's not what's important. What happens is the typical robbery. We're going to look at the general robbery and whether or not that's a crime of violence because it's whether by its nature it's violent or not. Okay, let's give that a shot. The respondent, James DeMira, is a lawful permanent resident of the United States, so he has a green card, that's what that means, with 2 convictions for first-degree burglary under California law. Well, this might present a problem, right? He's a green card holder, so he's not a citizen, and he has 2 convictions for first-degree burglary. Let's figure out whether or not that's a crime of violence or not. After his second offense, the government sought to deport him as an aggravated felon. An immigration judge and the Board of Immigrations held that California's first-degree burglary statute is a crime of violence because, first-degree burglary. Probably. While DeMaya's appeal was pending in the Ninth Circuit, this court held the similar residual clause in the Armed Career Criminal Act, which is never-ending source of litigation, defining felony as any felony that otherwise involves conduct that presents a serious potential risk of physical injury, was unconstitutional, void for vagueness on the Fifth Amendment's due process clause. So relying on Johnson, the court said that as incorporated into the Immigration Act, this was also unconstitutionally vague. So Congress, when it wrote "and other stuff," and other violent stuff, the Supreme Court eventually determined that, no, we can't really do that because, you haven't been specific enough. So, yeah. So the question is whether or not the Armed Career Criminal Act logic, which has very similar language, would read on the Immigration Act. And the Ninth Circuit said, yeah, it does read on it. And for the same reason, it's unconstitutionally vague. And so judgment affirmed. So that is all that. A straightforward application of the Armed Career Criminal Act effectively resolves the case. Section 16B has the same 2 features as the ACCA's residual clause, an ordinary case requirement and an ill-defined risk threshold, combined in the same constitutionally pragmatic way. To begin, the Armed Career Criminal Act statute's residual clause created grave uncertainty about how to estimate the risk posed by a crime because it tied judicial assessment of risk to speculative hypotheses about an ordinary case. What is an ordinary case? That's a good question. And it absolutely provided no guidance on how to figure that out, what an ordinary case is. Could be an issue. Compounding that uncertainty, the Armed Career Criminals Act's residual clause layered an imprecise serious potential risk standard on top of the requisite ordinary case inquiry. What is a serious personal risk? What is an ordinary case? What does that mean? Good questions. Not when it comes to criminal law, gotta be a little bit more precise than that. Compounding the combination of the indeterminacy about how to measure the risk posed by the crime and the indeterminacy about how risk it takes to qualify for a violent felony resulted in more unpredictability and arbitrariness than due process tolerates. So, there's people sometimes who think that any ambiguity in a statute makes it dead, and that's not the case. Even in criminal statutes, it doesn't have to be super precise. It does have to alert you to what the thing is, but it doesn't have to spell everything out in excruciating detail. Some people seem to think that criminal statutes need to spell everything out in excruciating detail. No, we don't need to do that. But by the same time, we can't be so vague that you have no idea what you're talking about, right? So if it said burglary, it's like, well, I don't know what burglary is. What's burglary? It's like, go away. You know what burglary is. Everyone knows what burglary is. You're in someone's house. You're stealing stuff from their house. That's burglary, right? You go in a bank. You steal stuff. Burglary. Great. That's super easy. So, yeah, no. But when it's like, well, other violent crime or substantial personal risk, or it's like, well, I'm not sure what that is exactly. Supreme Court's, yeah, that's too much. This is too void. This is too vague. Too vague to give ordinary notice. On a criminal statute, need to be a little bit more precise than that one. The government identifies 3 textual discrepancies between the ACCA's residual clause and this one because, they're not exactly word for word identical. It's basically the same concept, but then again, Congress used different language. So they must have meant something different, or Congress just can't be bothered to use the same language twice or something. So the government argues that these differences somehow make the immigration statute much easier to apply and cure the problem. So even though the ACCA, with very similar language, our language is defined enough that there's not a problem. So, but the Supreme Court holds that none of these related pair of features that Johnson found to be impermissible otherwise makes the statutory inquiry more determined. It's like, no, there might be differences, but those differences do not help. They're just different vague words. So different vague words is not more helpful. That's just different. First, the Supreme Court argues the immigration statute's express requirement that the risk arise from actions taken in the course of committing the offense serve as a temporal restriction. In other words, a court applying the statute may not consider risk arising after the offense commence is over. I'm not sure that necessarily follows. I don't know if in the course of, I'm not sure that necessarily follows. When you say in the course of doing the event, that doesn't immediately necessarily mean only as it's happening. What is the course of the action? Wouldn't the course of the action probably at least somewhat imply some stuff that happened before and some stuff happened after? Doesn't the purse snatching case, for example, wouldn't that suggest some things that occurred before the purse snatching first happened, and maybe some things that happened after? So, is the course of committing it really just limited to the moment of the taking, or is it a little bit broader than that? The government said, well, not after. Okay, well, but this is not a meaningful limitation in the ordinary case of any offense. The risk of crime arising from events occurring during its commission, not events occurring later. Yeah, typically. So with or without the temporal language, a court applying the ordinary case approach, whether in this statute or the ACCA's residual clause, would do the same thing. Ask what happens typically when a crime is committed. The phrase in the course of makes no difference in either outcome and cannot cure this problem. Second, the government states that the immigration statute's inquiry, which focuses on the risk of physical force, trains solely on conduct typically involved in a crime. In contrast, the ACCA's residual clause asks about risk of physical injury, requiring a secondary inquiry into a speculative change of causation that could possibly result in a victim's injury. So, physical force, the government argues, is defined to only the moment of force. But physical injury goes beyond that. That's reaching, man, but you got to give them points for trying. However, the court has made clear that physical force means force capable of causing physical pain or injury, which, So under the relevant statute, a court must not only identify conduct typically involved in crime, but it must also gauge its potential, theoretical, normal, average consequences. Thus, the force injury distinction does not help clarify the analysis of whether a crime is described as violent. Third, the government notes that the immigration statute avoids the vagueness problem of the Armed Career Criminal Act statute's residual clause because it is not preceded by a confusing list of exemplar crimes. The ACCA's statute is even worse because its exemplar crimes have their own problems. The enumerated crimes are in fact too varied to assist the court in giving ACCA's clause meaning, but to say they failed to resolve the clause's vagueness is hardly to say that they caused the problem. So there was a whole specific list of stuff, and there's a good rule of construction that when it says and other stuff, the other stuff has to be interpreted in the light and spirit of the things that preceded it. Unfortunately, the Supreme Court concluded in this particular case that the and other stuff clause was really, really bad. And even to make it worse, the list of specific things was also really, really bad. So yeah, the thing that the specific stuff didn't help, but it wasn't the problem. This problem was the residual clause. Yeah. The government also relies on this judicial experience with the immigration statute, arguing that because it's divided lower courts less often, so the courts are less confused or less contradictory, so therefore it's super clear. And resulting in only one certiorari grant, it must be clearer than its counterpart. But in fact, a host of issues respecting the immigration's application to specific crimes divide the federal appellate courts. And while this court has only heard oral arguments in 2 immigration cases, this court vacated the judgments in a number other of cases, remanding them for further consideration in light of ACCA. So yeah, we've only heard oral arguments twice, but it's a bit of an error to say that we've only granted certiorari once. We granted certiorari in a whole number of cases and then GVR'd them, which counts. We grant, vacate, remand. Consider it again. That's a grant of certiorari. Yeah, that's a grant of certiorari. It's just a different one. It's Supreme Court not saying we won't hear your case. It's saying we will hear your case. We just heard your case, and our result is this. It's a GVR. Grant, vacate, remand. We grant. That's the first part of G. Grant. We grant the request for certiorari. It's right in the name. Grant. We vacate. The decision below doesn't exist anymore, and we remand. Give it another try in light of this other opinion. We granted certiorari. It's right in the name. So yeah, no. No. Thus, that brings us to the end of the case of Sessions versus Dima. In this case, Mr. Dima was convicted of fairly serious offenses, first-degree burglary, and the government thought that this qualified as an offense to expel him out of the country. Unfortunately, the Armed Career Criminal Act, which is written very similar to this and has kind of legendary status at this point in terms of the amount of litigation it's had over basically the exact same issues, has basically pointed to the flaws here. And the Supreme Court says, basically in so many words, go read all those other cases. We have found this to be a problem. We don't know how to do this. We don't know how to apply this. It's too vague. And we can't apply it anymore here either. So, Congress, if you want to expel people for being felons or violent felons, you got to help us out. Maybe you could be a little bit more clear on that language in some way. That would be great. But at least for the moment, that brings us to the end of the consideration of this case.